So at least the first gesture should be, at least between the BRIC countries, the arbitration law must be the same so that your awards are enforceable in each other's countries without any difficulty. We have the next speaker before you is Mr. Leonardo from Brazil, assistant professor in graduate courses at the law school. He speaks on international arbitration and dispute resolution. May I request you, sir, please.
Thank you, sir, for the introduction. Ladies and gentlemen, good afternoon, privyet, ni hao, boa tarde, and of course, namaste. Thank you. Since I guess you've all noticed by now that international arbitration and dispute resolution within the BRICS community is key in this third BRICS Legal Forum. It's been discussed more than every other subject that we've been talking about. So my intention here is to talk to you about some aspects of the way, from the Brazilian standpoint, about a very recent reform in our Arbitration Act that specifically provides for the public administration to take part on arbitrations involving, of course, the Brazilian state. Well, the Brazilian Arbitration Act itself is from 1996, and not only until 2001, when our Supreme Court ruled on its constitutionality, it became clear that the whole process of arbitration itself was accepted in Brazil. There was a general lack of trust in non-state dispute resolution systems, and I think it's safe to say that there still is a lack of trust in arbitration in general in Brazil. Now it's a growing issue, it's a hot topic that's becoming more and more talked about in Brazil, but we're still learning how to deal with commercial disputes, and moreover, we're still learning how to deal with the public administration taking part on investment arbitrations in Brazil. It is kind of a new subject due to the lack of trust. So then, as I was saying, just last year, there was a recent reform that stated that public administration can take part on arbitration involving patrimonial waivable rights. And this arbitration will respect the principle of publicity. So we should be talking about those two subjects. Well, as an example of the lack of trust that I could share with you, in 2002, that means more than a decade after our Arbitration Act has been passed, an important ruling of our Federal Court of Auditors recommended that the Brazilian Transportation Agency didn't arbitrate concession issues, meaning that we still have to get a more mature approach to whether we're about to embrace arbitration in investments or not, especially after we've seen all of the rest of the BRICS countries talk about arbitration like this. I think it's interesting to see how in Brazil this whole discussion is still beginning to become more mature. Anyway, it's been noted that from the foreign investors' point of view, there can be some lack of trust right on the other side, on developing countries' judiciary systems due to possible protection of national agencies instead of, or a biased approach in favor of national agencies instead of balancing treatment between investor and state. And on the other side, the lack of trust of countries or developing countries into, for example, signing and ratifying ICSID conventions due to the possible bias in favor of investors and not in favor of national communities. So that's being discussed in Brazil a lot. And especially after the World Cup and, of course, the Brazilian World Cup, and due to recent events in Brazil, with possible economic instability and possible economic attractiveness for foreign investors, time has come for us to speak more freely and more openly about investment arbitration with involving concession law, mining law, oil law, port law, and allowing international investors to be welcomed in Brazil, for Brazil to be seen as a more welcoming investment place for cash inflows. Anyway, it has been said in Brazil specifically that due to case overload, and we have been just listening this morning to Mr. Divan talk about the Indian judiciary system. It has been said, due to case overload, a probable lack of judges, and a very, very slow judiciary system, and I guess the Indian problems are kind of similar to what we have in Brazil, investors tend to demand arbitration clauses in funding and in concessions and in bilateral investment treaties alike. So then, it has been proven that our Brazilian judiciary system is fairly independent, such as the Indian judiciary system. But that doesn't prevent for lack of trust to happen, especially if we're talking about investments from developed countries, the so-called developed countries, into the BRICS countries. That kind of trust environment has to be slowly built. And for that to happen, arbitration courts, such as the Delhi court that has been recently created, come in the right time for the perfect balanced environment to be created. Anyway, it has also been said, specifically in Brazil, that public interest matters are all non-waivable, meaning that the public administration couldn't be or couldn't take part into arbitration whatsoever. And I believe that this is a subject of the past in most countries that have arbitration for decades now. But still in Brazil, there is some room for discussion about this. So then there is doctrine, and there are still jurists talking about non-waivable public rights and the non-existence, the so-called non-existence of waivable public rights. This is something that we certainly have to overcome in order for us to embrace international arbitration as an institutional thing in Brazil. Anyway, in 2010, this is a piece of good news. In 2010, the Attorney General's office in São Paulo drafted a standard arbitration clause in which state investor disputes were to be arbitrated. That means that public attorneys were finally allowing for arbitration to take place. And in that standard arbitration clause, it was stated that arbitration could take place in economic and financial rebalancing of contracts, compensation for breach of contract in whatsoever cause, and interpreting contract clauses. This was a first step for us to deal with investment arbitration in Brazil. Anyway, during the 1990s and until now, I could say that Brazil has seen a paradigm shift in foreign direct investments, probably due to the privatization in the form of concessions of public service. So we have a telecommunication statute, an oil agency statute, transportation statute, and most recently a port statute, all providing for arbitration to take place when there are breaches of contract to happen. But still, fully structured concessions, the ones that comprise the famous design, build, finance, operate systems, are very rare in Brazil, and public-private partnerships are still yet to come to happen in Brazil. It's still, we're taking slow paces in that area, specifically, and I believe due to this lack of trust that has been placed from 1996 and on, when it came to non-state dispute resolution systems involving foreign investors and our national state. And of course, in the rest of the world, the ICSID, the World Bank's International Center for Investment Disputes, has been going on since 1965, and we do know that Brazil, India, and South Africa are countries that are non-members of the ICSID, and Russia, I believe that it is a member but hasn't ratified the ICSID, and so that all comes to prove that when it comes to investor and state relationships, the BRICS countries have something alike, and that might be the necessity to create common environments for our developing countries' common needs to be fully understood, and for our complexities to be fully understood in order for us to strive in this non-state dispute resolution systems. And just to clarify about what I've been saying about general lack of trust, I found some recent studies that prove that more than 90% of bilateral investment treaties, they operate without any claims whatsoever. From those 10% that really require arbitration, more than half of that are ruled in favor of states and not in favor of private investors. Some other 30% are settled, and only more or less 20% are ruled more or less in favor of investors. So then the states or the national states' reason to discredit arbitration is statistically not really justifiable, which is, again, another reason for us to think about alliances between law practices. It should be advocated a little more among the BRICS countries, and for us to defend the creation of BRICS forums or BRICS courts of dispute resolution, not only among the BRICS countries, but hosted in a BRICS country for developing countries to be able to take part on dispute resolution systems whenever there's investor-state relations being breached or contracts being breached. Anyway, after the recent reform in Brazil, some points that I have to stress about a reform. First of all, of course, publicity is mandatory. So, as we know, the confidentiality aspect was often seen as an advantage in commercial arbitration. That cannot be the same in investment arbitration for obvious reasons of accountability. Well, since a couple of years ago, since 2014, the UNCITRAL rules on transparency in BITs and state investor arbitration sets, it sets up publicity as a general rule for arbitrations or for investment arbitrations. Also, the United States and Canada's bilateral investment treaty models both contain disclosure obligations regarding information related to the procedure, and I believe, and I may be corrected if I'm wrong, that the Indian BIT model doesn't say anything about publicity. Even whether if disclosure is mandatory or if it's not, I didn't find anything about it, and Brazil doesn't have a BIT model text yet, so we're still to draft something in that direction. Anyway, all information should be made public when there's the Brazilian state taking part in arbitrations, in investment arbitrations, due to our new recently published law. Also, there's been some discussion about public bidding to select arbitration courts. Since all public contracts must be subject to public bidding in Brazil, it has been often discussed that the arbitration court must be subject to a public bidding. The choice of the court must be subject to bidding. And finally, there's been discussion on whether is arbitration provision or the provision of the clause necessary on the auction notice, on the bidding invitation, that will result in a concession or in a contract to be taking place. For that, I have to say that the Brazilian law doesn't state or doesn't say anything about whether if it's necessary. Although a provision stating that the necessity of the arbitration clause appeared on the auction notice was rejected during the legislative process in Brazil, so we can take that as an argument to say that no, it's not necessary for the public bidding, or the contract to be taking place, for it to state that arbitration is mandatory in a future or eventual breach of contract. Anyway, to come to a conclusion on what I've been saying, I guess, and it's been widely noted in Brazil, that there's a decree regulating arbitration in port matters, only portuary matters, that can be used as a model in Brazilian investment arbitrations, because it's probably the most complete piece of, most complete body of law that we have, talking about investor-state relations being solved by arbitration. And so this decree, it's from 2015, it states that every breach of contract and economic and financial rebalancing might be subject to arbitration when involving states and foreign investors. It does also state that all information whatsoever must be made public, so the duty of disclosure is taken to a very rigid standard in Brazil. Also, it states that the private investor has to put forward the costs of arbitration. He is the one with the burden of advancing the cost of arbitration. And on the other side, it is the public administration, the Brazilian public administration, one-sidedly to decide which is the value of the claim, and that has clear effects on legal fees, for example, the calculation on legal fees. It is not an agreement, it is just the public administration burden to tell what's the value of the claim on such arbitrations. Also, and responding to the doubt about whether there should be public bidding or not, for choice of courts, this model, this decree states that choice of courts and of arbitrators is considered to be an exception to public bidding in contracts for services. So then our very rigid administrative law in Brazil now gives some space for us not to subject or submit all arbitrations to public bidding for a choose of court, which would of course take a lot of more time and would be not very cost effective. And as a conclusion, the same decree states that arbitration is preferred over judicial disputes in some situations. The first of all, when claims involve technical rather than juridical issues, and this has been the most frequent argument in favor of investment arbitrations rather than resourcing to judicial dispute resolution systems, because of arbitrators being more often more prepared to deal with more complex economic and rebalancing aspects, complex aspects. So then when claims involve more technical than juridical issues, arbitration is to be preferred. Second situation would be when a slow judiciary process could obstruct service to be provided in a standard way. So then if the service is to be stalled because of judiciary slow processes, then arbitration should be preferred. And finally, to come back to the lack of trust and discredit issues, when slow process could prevent priority investments to be made, arbitration should be preferred to judicial dispute resolution systems. That means that finally, after some 2 decades, the Brazilian legislature in a general manner has noticed that international investment will come, and will come in a speedier manner, if we understand that arbitration clauses and unbiased arbitration courts, such as the one recently created here in Delhi, and such as the one created last year in Shanghai, or probably the South African that's underway, and I don't know, maybe a Brazilian court that we have to study about creating. Anyway, the creation of those courts that can fully understand the complexities of our developing countries might attract international investments to Brazil, more than has happened in the last years due to all of these difficulties dealing with the judiciary system in developing countries. And by saying all of this, I want to say that I'm really privileged to have been invited to an event like this, a very well-organized event. I think I can say in the name of all the Brazilian delegation that we feel privileged to be welcome by such joyous and by such happy people such as you. And so thank you very, very much for having received us and for having organized this beautiful event. I've started what I was saying with a little hello in every language, so I have the duty to say goodbye in every language or thank you. So then you should excuse me for my mispronunciations that will happen. So I do know thank you very much. I know spasiba or something like this in Russian. I know tsiektie in Chinese, and I know the Chinese won't think my pronunciation is very bad. Of course, I know muito obrigado in Portuguese, and of course, bahut dhanyavad for everybody. Thank you.
Thank you, sir. It was really a professor teaching us something in law for the overview that you have given us. And I think we have already started learning on each other's, at least the namaste and what you have to talk in all the languages. So I think we should exchange that between us so that